I'd like to introduce to you the moderator of our next panel, Voter Registration and the Path to the Voting Rights Act, Charlie Nesson. Charlie, that's how we all know him, who served with him in the division 1965 to 1966 when he was a special assistant to John Doar. Charlie has had a long and distinguished career as a professor of law at the Harvard Law School, where he now holds the William F. Weld Chair. He's taught civil rights, constitutional rights. He works with Professor Charles Ogletree at the Charles H. Houston Center for the Study of the Black Experience in Education. He's currently teaching a seminar, if you can believe it, on Lowndes County, Alabama civil rights litigation. Those of you who served with him will recall that he helped prepare and try the division's lawsuits challenging jury discrimination and school segregation in Lowndes County, Alabama, which was his assigned geographical bailiwick. Charlie was one of the original moderators of the Fred Friendly seminars, where Friendly, who was a partner of Edward R. Murrow and a CBS mainstay, and Charlie would pose questions to a ring of knowledgeable experts on the pressing issues of the day. Their well-framed, rapid-fire questions drew from each participant the contribution he or she could make to the resolution of the issue at hand. That's what Charlie will do here. He will introduce the participants in the panel. There'll be an opportunity for your questions at the conclusion of the panel's discussion, and I look forward to the exchange with great anticipation. Thank you.
Thank you. Let me just begin by thanking Steve Pollack. An event like this just doesn't happen unless there's some energy at the core of it. And Steve is the energy, and Dorothy Landsberg is the backup, as she has always been. So, introductions. John Sigenthaler. John, tell us who you are.
Well, Charlie, there's a paragraph written at the bottom of page 2, and why don't they just read who I am and pass it on to Chuck?
I sort of have a feeling that we know who John Sigenthaler is. But as the dean of journalism, in some sense, through this whole period, and as someone who was such a close advisor of it, it just seems like a wonderful opportunity to have you on this panel. Welcome.
Thank you, Charlie.
Chuck McDoo. Chuck McDoo, tell us about yourself.
I'll tell you what John told you. Read it. I was a past chairman of SNCC, and I want the SNCC people, Giyad, Joan, and if any other SNCC people, Tim, are you here? To stand. And I was chairman of the Student Nonviolent Coordinating Committee from 1961 and until about the March on Washington. So when I want to get back to the field and be involved in voter registration rather than hustling money and things like that. Thank you.
And John Doar, tell us who you are.
You have the same response.
No, I have to have one response from you. It's got to be, I'm John Doar, D-O-A-R, from New Richmond, Wisconsin. That's the way I heard John introduce himself so many times. All right, so here we are to talk about the lead up to the Voting Rights Act. Just stop for a moment and think about the Voting Rights Act. It's the most extraordinary piece of legislation, unprecedented in American history. There was no legislation that I can think of done by Congress that so radically changed the relationship between the state and federal governments. There's no legislation I can think of that separates out
Tell us who you are.
Yeah, exactly. No legislation that separates out a set of states and imposes the kind of constraints that the Voting Rights Act imposed on those states. And no act that more radically changed something that seemed to be immutable. For me, this story, it can start anywhere, but for me it starts with Brown versus Board, which I tend to think of in terms of just 9 old guys, and at the time, like 18 kids who were their clerks, who write this momentous decision that puts into issue the caste system of the United States. And when you think about this tiny institution, which has no police force of its own, and which deals with law as its instrument, yet recognizes how entirely fragile the law is without enforcement in back of it. It starts the story in a way that in some ways is trepidatious. I think about the justices of the Supreme Court after Brown, waiting to see what the response would be of the United States government in the form of the Congress and the executive branch, and waiting really trepidatiously right up through the point where Eisenhower federalized troops and sent them into Little Rock. That was a turning point. In 1960, Jack Kennedy gets elected. He appoints his brother Attorney General. And his brother, Bob, appoints Burke Marshall head of the Civil Rights Division. John, tell us how that happened. You were there. Tell us the story. How did Burke Marshall become head of the Civil Rights Division?
Well, he was an antitrust lawyer at Covington, and he was like Byron and many others Robert Kennedy selected as part of that Justice Department cabinet. He was out of Yale, and Byron proposed Burke to Bob, and there was a discussion about it, and I don't know, Vi, that you've ever heard this, but I opposed that in every way I could. I favored, I had been active in the campaign. I'd worked as Bob's assistant during the campaign, and I strongly favored either Harris Wofford or Morris Abrams, both of whom had been extremely active in the campaign, and I knew their commitment was total, was complete, and I knew their emotional involvement in what was already becoming a movement was absolute, and so I raised my voice in their behalf. But Byron was wise and very strongly in favor of Burke, and ultimately Bob decided that that was the way to go. In talking to me about it as he made the decision, he said that, first of all, he had great confidence in Burke as a result of their discussions about the direction the division would go. And he also said, I don't really think, with Jim Eastland, chairman of Judiciary Committee, there is any chance that within the next year, either Harris Wofford or Morris Abrams could get named Assistant Attorney General for Civil Rights. And so Burke was selected. I do remember Senator Eastland asking him in that hearing, and there was one, Mr. Marshall, how much money have you contributed to the NAACP? And Burke said none. And Eastland said, and how much have you given to the ACLU? And Burke said none. He said, could you tell me to what organizations you have contributed money? And Burke said, I think I gave $150 to the Maryland Democratic Party during the 1960 campaign, but Senator, that's about it. And so he slid through the Judiciary Committee, and I was wrong. Burke Marshall had a steel mind and a steel backbone, and his commitment was absolute. And beyond that, he was so creative and so innovative that he put that division on a new track.
And just say a word about your relationship with Bobby. What was it at that point?
Well, it was very close. I had been a reporter in Washington during the years of McClellan Committee. At the end of that, I had been a Nieman Fellow at Harvard, and he came up and said, look, in 1958, I'm leaving the committee. I want to write a book. Would you come help me with this book? And so we lived together about 5 months at Hickory Hill, and from that point on, we bonded. And during the campaign, there had been a change of editors at the newspaper. The new editor was not somebody that David Halberstam and Tom Wicker and I wanted to work for because of civil rights change in the policy. And so I was looking for a job as they were. They found jobs with the New York Times, and I found one in that campaign and later in the Justice Department.
All right. So, John, Burke Marshall comes in. He meets with Bobby Kennedy. What was the mandate? What did Bobby Kennedy want Burke Marshall and the Civil Rights Division and you to accomplish?
Well, he wanted action, and he wanted it yesterday, not tomorrow. And he wanted to accomplish something. He wanted to see the action, the court cases, mean something, and that was the direction, and it was loud and clear.
Tell me about the division then.
Well, the division at that time was very small, and not all the lawyers in the division were working on voting rights cases. Maybe there was 5 or 6 of us working on voting rights cases in 1961. Fortunately, St. John Barrett and Harold Green were involved, and they were great lawyers, great scholars. And then there was 4 young lawyers, Bob Owen, Dave Norman, Frank Dunbar, and Nick Flannery, who were just out of law school, and they were ready to work. And they were remarkable lawyers as well. And it was our job to learn about the South, all about it, and the only way we could learn about it was to go down ourselves. And so we began to travel. And when the first time I met the Attorney General, Burke said, well, General, if you want us to accomplish this, I've got to have more lawyers. And Robert Kennedy said, how many? And Burke said, 4. Can you believe it? But luckily, the first 2 lawyers that were hired were Bud Sather and Jerry Stern, who came right after Robert Kennedy came in office, and they too went right out into the field.
But now you yourself had been litigating voting rights cases before in Tennessee, yes? Haywood County?
Yes, I came to the Department of Justice after July 4th, 1960, and there was a case that was being investigated in Haywood County, Tennessee, where black residents were trying to register. There were no educational qualifications in Tennessee for voting, and as a result of their efforts, which was at that time a very community-based effort, not a national effort, the white power structure in Haywood County began to apply economic pressure against the blacks, particularly against the black sharecroppers who worked on the big cotton farms in Haywood County, which is very much like the Delta in Mississippi. And so another lawyer, Nick Flannery, and I went down to Haywood County, and we asked if we could talk to some of these farmers, and arrangements were made we'd meet them at a church, a rural church, black church, small church. And we went out to the church at sundown, walked into the church, there's probably seven pews, and walked up to the front, and we explained who we were. We were from the Justice Department. We were there to try to help them. And we asked, how many of you have been asked to get off the land? How many of you have been asked to move? And there were probably 50 husband and wives there in the church that night, all black, of course. And every single person in the room raised their hand. Well, when you get exposed to something like that, it has an impact on you, and it seems so cruel and so savage that people that had lived on the farms, worked on the farms for sometimes 2 generations, 3 generations, as sharecroppers, were being asked to move. And we talked to those individuals and went out to their houses and took pictures of them in front of their little shacks with their children. And it was a very, very compelling story. And thanks to these 6 young lawyers, particularly Owen and Norman, we put a case for motion for preliminary injunction, and it got it filed within 20 or 25 days. And that was the beginning of how we worked.
Do I understand right that the brief that you filed in that case was one of the first that ever had an appendix with photographs in it?
Well, I don't know. You're covering a lot of territory. But it was an appealing appendix because these pictures of these families standing in front of their little houses out in the field, 3 kids, 6 kids, 8 kids, and the parents of those children were just very, very fine people. They weren't educated. They didn't have much schooling, but they had character. And they were not whiners, they were not complainers, and they were not trying to ask for somebody else to do something for them. They organized themselves, they and the people in the next county, to register to vote. And so it was a privilege to represent them, although we really didn't represent them, and then we represented the United States. And that was an important difference.
But I sense in that early case a strategy of litigation that seems to me to have characterized almost everything that came after. That is...
well, the thing about it was litigation. We didn't ask the lawyers to write Supreme Court briefs. If you know if the Supreme Court brief is, I've never written one, so I can fairly be maybe entitled to comment. But Supreme Court briefs are reviewed by 2 or 3 lawyers before they ever get out to the front office, and they're beautifully crafted legal documents. But we didn't have time for that. Our job was to move and move quickly, move the day before yesterday. And so our mandate was to tell a story, make it interesting as to what's happened, and make it as tough as you can from the standpoint of the appeal of the story, but get it out, get it on paper, check it, be sure that it's accurate, nothing but facts, no adjectives, no adverbs, just nouns and verbs, just nouns and verbs. But do it today. Have it ready tomorrow. Go to Texas tomorrow morning, or to Tennessee tomorrow morning, or Mississippi tomorrow morning, and file it before noon. That was the strategy. And of course, fortunately, these lawyers and the lawyers that came after them, the young lawyers, were terrific, and they bought into that strategy, and as a result, they worked and worked and worked and worked and worked, and they traveled and they traveled and they traveled and they traveled back and forth through Mississippi, Louisiana, and Alabama, all during 61, during 62, 63, and 64, and they came to know the territory and to know the people and to know the witnesses, and they were comfortable with the people, with the black rural people in Mississippi. And then we also came to know the Student Nonviolent Coordinating Committee, which was really, if you want to talk about the people that really created the momentum for the Civil Rights Act, Voting Rights Act of 65, I have no doubt in my mind that the large credit for that is the Student Nonviolent Coordinating Committee. Guys like this guy, Chuck McDoo, sitting next to me, down in Mississippi, day and night in the rural counties. You know, that was not any easy work. There was nothing easy about it. And these kids were tough, and they were not going to back down. And they kept at it in some of the places in Mississippi, Southwest Mississippi in 61, the Delta in 62 and 63, where just some awful, awful things were happening to them. I don't know how they were so lucky to get by with so little people, so few people getting hurt, but they were in jail and out of jail and harassed and beaten, and their office was burned, or they were chased around the counties, and but they kept meeting with people and getting the rural black citizens of Mississippi and Louisiana and Alabama to have the courage to go up and try to register to vote. And as they did that, they created for us the witnesses that we used to put these cases together.
So before I leave Haywood, John Sigenthaler, John's work in Haywood County had an effect on that 60 election, didn't it?
Well, as a matter of fact, it did. And I didn't understand it until later. Active in the campaign and being a Tennessean, I was very anxious that that state did what it could to go for Kennedy, and I knew a couple of young lawyers in Memphis, Russell Sugarman and A.W. Willis, really very bright and very dedicated, and both they were African American, and they were totally committed to Kennedy. And when the votes came in November, and I looked at my home state, recognized the boxes that were traditional black boxes from all the way back to the days of Crump there in Memphis. Kennedy carried those substantially, some overwhelmingly. But when it got to Fayette and Haywood counties, Tent City, where John had gone in and filed the lawsuits, it was the reverse. Those counties went overwhelmingly for Vice President Nixon. And I didn't know until one night, and John may not remember this, one night John and I were in Birmingham having dinner, and I was sort of recounting the election and mentioned the fact that those counties had gone for Nixon, and looked at them and I thought I saw just a trace of guilt come over his face. I always, ever since that day, I've blamed him for disrupting the vote in Haywood and Fayette County.
All right, Chuck McDoo, where were you, what were you doing in 1960, 59, 60?
1960.
Yeah, before you rise to the chairmanship of SNCC, tell us a little bit about what that was like. Like, how did it get there? What brought that?
Well, I came from Ohio. I was born and raised in Ohio, a place called Massillon, Ohio. And I was a little hotshot football player, and in Massillon, that's how you escaped. So my life was planned for me. I knew what I was going to do by the time I was 16, 15, because graduated college, high school, 16. I was going to play ball at Massillon High. I had already had scholarship offers to Michigan and Ohio State. That's where my family members go. And so I was going to go to play ball at Michigan and go on to the pros, make a few dollars, retire, marry a good-looking woman, have smart kids, and then buy a liquor store, a used car lot of whatever they do. And but it was my father's belief that we all, me, my brothers, and my sister, had to, it's a family rule that you spend at least 1 year at a historically black college. And I spent the first year, I was sent to South Carolina State in Orangeburg, South Carolina. At first, it was just wonderful because there were girls. I was 16. There were all these beautiful black girls, and I came from Massillon. There were like 2,000 black people in the city, and most of them were related. And I can still hear my mother saying, "You like who? Boy, don't you know that's your cousin?" So I got to Orangeburg, South Carolina, and I was liberated. I mean, there were all these beautiful black girls, more black girls than I'd ever seen in my life, and more black people.
This story leads straight to SNCC, right?
Right. So, shortly after that, I became involved. I became involved in the sit-ins, which started in February. And a group of students asked me to be their spokesman in the sit-in movement. And first I said no, because these white people are crazy. And you all ain't wrapped too tight to put up with them. But I'll be leaving South Carolina at the end of February, and I'll never be any further south than Columbus in my life. But shortly after that, I was reading the Talmud, and it's a statement: "If I'm not for myself, who will be for me? If I'm for myself only, what am I? If not now, when?" And after reading and thinking about that, I joined these students and became a part of the sit-in movement. And the leader of the group and spokesman at South Carolina State College. A meeting was called in Raleigh by SCLC. Out of that group grew the Student Nonviolent Coordinating Committee. And at our first, when we first met, formally after that meeting in October, I was elected chairman of SNCC. And as SNCC grew, we felt that what we had to do, there were two things. One, that wherever you would do something, any of us had done something, the would be a response by the white community as saying, yeah, you might have desegregated the libraries here in Tennessee, or you might have done this in Kentucky or Georgia, but you would never do it in Mississippi. And you'd sort of say, yeah, that's true. And we sort of agreed with that. And then we talked about, unless we change Mississippi, it doesn't matter what we do in any of these other places. So we had to mount a program and a strategy to change Mississippi.
Why? Say why. Say why. Why do you have to change Mississippi?
For the reasons I just mentioned, that if we were successful other places and were not successful in Mississippi, we felt we hadn't really done anything, because Mississippi was the South Africa of segregation. Mississippi was very naked in their opposition. They said it all the time. Governor Barnett was yelling, segregation now, segregation tomorrow, segregation forever. He threw down the gauntlet. We picked it up and slapped him with it. We said, all right, he threw down the challenge, and what he got was us. He got the Student Nonviolent Coordinating Committee. And one of the things we were saying, a place like this, it can't just be sitting in and things like that. We have to change the structure of this place. And in order to do that, we have to be able to amass the people who are being denied the right to vote, because we had the Eastlands, the Stennises, the Pattersons coming from areas that were primarily black, and black people didn't vote. And black people didn't vote because they were apathetic. They didn't vote because they were frightened, and that there was going to be a heavy price to pay if they tried to vote. And so we put together a program to register people to vote, because we felt, and if we did Mississippi, then we said it's possible to change any place in the world. Mississippi was so bad that we felt if we could change Mississippi, we could go after South Africa, and then, we could do it anywhere. And so it became our primary, although we worked in other states, Mississippi became the primary area where we had worked. And we explained this to the Justice Department. Moses talks about there being then an effort of pressure coming from above and below. The above was justice, and below was us, was SNCC and the people we were organizing.
And you weren't just going into the cities; you were going to the most rural parts of Mississippi.
Yes, in fact, we had a meeting at one point with the Taconic Foundation, where they said they were willing to fund us to go into the cities. Our proposal said no. It outlined rural counties, and we said you will be there eventually, because that's where all the action is going to be. That you cannot not be there. In fact, and so that's how I came into contact with these guys. I remember with Sigenthaler with the Nashville Tennessean, and we said it was one of the only papers in the South that had really good reporters, and we need to meet with them, talk with them, have them become our allies, and so we reached out. And then with the Justice Department, there was a question just before the break. Brian asked about SNCC's relationship with the Justice Department. I remember I was talking with the head of our Alabama project, Bernard Lafayette, and Bernard was talking about he was in court in Montgomery, and he said something, answered the question the judge put to him, and said no, and the prosecutor said, will say no, sir. And he said, and Bernard said, I just said no. And the prosecutor said, I say no, sir. And, or you're in contempt. And he said, and our lawyer said, he answered the question. So our lawyer, who our lawyer? He said, John Doar was there. I said, oh, right. And then, and so there was, plus there was this tremendous relationship and understanding. Many of our people, it was true. And though John told me this 1,922 times, we cannot act as your lawyer. But I told our people, keep this number in your pocket. This is John Doar's number. And if something happens, that's what you call. In fact, I was telling John today, the first time we brought people from Amite County to Washington to testify to the Civil Rights Commission. It was one of the few places we could get testimony in the records. And Mr. Steptoe, who used to say, I hope before I die, I will vote 1 or 2 times in my life before I die. He never did vote 1 or 2 times before he died. But he kept trying all the time. Well, we came to Washington to testify to the Civil Rights Commission. And we stayed at John Adams, or Hay Adams, on right across the street, down the street from the White House. And I remember Mr. Steptoe, a farmer in Amite County. I helped him with his bags, and I said they were really heavy. And I threw them on the bed for Mr. Steptoe to unpack. And when he opened the bag, he had 4 weapons, 4 automatic pistols. And I said, Mr. Steptoe, you don't need those here. He said, is John Doar here? I said, no, I don't know where John Doar is, but he won't be at the. Said, then I need him. So that was, and that was significant of how we saw the Justice Department, as we saw them as in the struggle with us, because John had been to Mr. Steptoe's house and knew that it was. Well, we felt it was just as dangerous for him, but you as a SNCC person will have a better chance to survive if they have to blow him up to get you. So therefore, since we can't have Burke Marshall right here, stick close the door. and plus it did act as a shield. We could back some people up at times. I remember one time running from a group of people, and obviously wasn't going to be able to outrun them, and Claude Sitton of the New York Times waved me into safety. I got to his house, and there were these people out front, and he said, Chuck, come on in and have some bourbon. And I mean, they were there. They were like from here to the front row standing, these white men, really angry, and Sitton offered me to his room, gave me a drink as he loudly said, and John Doar will be here soon. So, and as I said, part of our strategy was to understand, in order for them to get us, they had to blow up a federal official. So, and we just didn't know if they were going to go that far.
So, John, would you just reminisce a little bit about your first meetings with SNCC, with Bob Moses, with the
Well, I first met Bob when he came to see Burke about what they were going to do in Mississippi, and he came into my office, and it was sometime after April '61. We had a large map on the wall where we had pins where we had started cases or investigations, and Bob was smart, and he studied that map and quickly noted that the first case we brought was in Dallas County, Alabama, and he put a field office in Dallas County, Alabama, almost immediately. The first time I had any time spent with him was when in I think September of '61, he'd already been beaten up in Ammett or Walthall counties, arrested, and found guilty of some kind of minor criminal offense. And he offered to show me around, so we went down to Mr. Steptoe's house in Ammett County, a rural little house out in a field, and sat on the front steps and visited about what was going on there. And he said that they were having voter registration schools, and that they were white people that were coming around pickup trucks and taking down the license numbers of the cars of the black residents. And I said, "Do you know who those white men were?" And he said, "No, but Herbert Lee does." And we asked where Herbert Lee lived. Bob knew Herbert, and he said he lived down the road. Well, we said, "Let's go down and see Herbert Lee." We went down, we couldn't find him. And I had to get back to Washington, so I said to Bob, we'll come back see Mr. Lee the next time I get here. And I got home with Washington the next night at 10 o'clock, and Mr. Steptoe's next door neighbor, a man named Hearst, who was a state senator, had got into a dispute at the cotton gin that morning with Herbert Lee, and he killed him, shot him. And that kind of experience marks you. And there was a black trucker, a marvelous man. He was a logging trucker named Herbert Allen. He was a very strong, straight guy, and he was intimidated to the extent, and the circumstances were such down there in Ammett County, it was like the 18th century, that he was entitled to be afraid. And he testified that at the coroner's jury that Mr. Lee had a tire iron when Hearst assaulted him. But he told Bob that he was forced to say that, confirm that. And we weren't able at that time, because of the laws and the required degree of proof we had to establish, to do anything about Herbert Allen. And he lived in fear of his life for another 2 years, and then one night he was murdered. That sort of experience for all of us in the division really made us work harder and harder. And we came to admire the Student Nonviolent Coordinating Committee, Chuck and Bob Moses and Bernard Lafayette and the rest of the kids, because what they were doing was just so heroic and so magnificent that it was not difficult to try to do all we could within the law to support them.
John Sigenthaler, in some way this is a story about the law, but it's also a story about the court of public opinion. And you were kind of onto this story. right from the beginning as like the story of the South. Could you frame it in the broader context? I know John's out there with his lawyers and SNCC, and he's filing lawsuits, but you're speaking to the world.
As a journalist.
As a journalist.
Yeah. Well, you have to. We sit here today and listen to John and Chuck recount those days, and they're eloquent about it, and they're wonderfully self-effacing. But Chuck was in danger of death every day he was in Mississippi. Bernard Lafayette was. Every day he was in Alabama. And there was danger, as John knows, for all those lawyers in the division who went into those rural southern communities and in the central cities. I mean, just think, more than 40 martyrs of the movement died as a result of this. All those southern states, virtually a no man's land. It was a war zone where they went and where John went. And the press, as Chuck said, was not just virulent. It was sometimes the editorials and the news stories encouraged violence. And so you look at the South today, and it's impossible to imagine that there was a time when you woke and you walked in fear. And just the sheer courage, the heart and soul that those kids gave and the members of the division gave to bring about a change in the law. It's a phenomenal story. It's the reason it's so great that there's so many of you here today to have these discussions about it. Because you can't look at the South today and imagine how violence-ridden it was, not just in those rural areas, in the central cities, in Jackson, in Memphis, in Atlanta, in Nashville. It was a war zone, and I will have to tell you, during those days I was a reporter, I never thought they would succeed. The opposition in a city like Nashville, thought of as moderate. The first night of school desegregation, of one child, school blown off its foundation. One little girl, beautiful little black girl. You just can't think back to those years and possibly imagine how dominant race was as a factor in every central city, every capital, and in every rural community.
All right, so John, Bobby Kennedy is saying, I want pins on the map. Mm-hmm. And Bob Moses is in there looking and he sees, yeah, you got a pin on Dallas County. Carry it from there. And tell us about Bob Owen and Dave Norman and how it happened.
It didn't happen by plan, I don't think. It just happened because we just were running as hard as we could. But President Kennedy appointed Judge Cox to be a judge in the Southern District of Mississippi. He really had no choice because that was Senator Eastland's man. And we litigated before Judge Cox, and one of the cases that come to mind is a case in Hattiesburg, which was the first case that Bob Owen investigated when he went down to Mississippi in May or June of 1961. And we finally got before Judge Cox on a motion for a hearing for preliminary injunction in March of '62, and we put on three days of witnesses. A young lawyer named Gordon Martin located 17 or 18 white college students that were willing to testify how easy it was for them to register. But at the end of the hearing, Judge Cox said he wasn't going to decide one way or the other because it was just in the middle of the hearing. We asked him if he wasn't going to give us a preliminary injunction and direct the registrar to be fair and then deny it so we could appeal. And he said no, he wasn't going to do that. But anyway, Bob pressed him, and when he didn't do it, he had made a record sufficient that we took an appeal anyway on the grounds that the failure to rule was equivalent to a denial. And then in the next 5 months, something really remarkable happened that probably has never happened before in history. And that was first, Bob and Dave moved for a injunction pending appeal to enjoin the registrar from discriminating. And Judge Tuttle, the chief judge of the old Fifth Circuit, granted a hearing on that on the 4th day of April, 1962 in Houston. And Judge Hutchison and Judge Wisdom and Judge Brown sat on that panel, and they listened to the first day of the Mississippi lawyers trying to argue sense out of nonsense, and they began to be educated as just what was going on with respect to the whole scheme and structure in Mississippi, more than they'd been educated through books or articles. And Judge Tuttle, within 4 days, issued an injunction, and the registrar immediately violated the injunction, and Bob was back in court again with a motion to hold the registrar in contempt, and that was on the 30th of April. So this all happens in a period of a month and 5-6 weeks. And then the question was, well, how are they going to, who's going to decide the question of whether Sarah Lynn was in contempt? And they talked back and forth, the three judges, and by this time Judge Hutchison had gone off the panel, and Judge Bell from Atlanta was on the panel. So we had Wisdom, Brown, and Bell. And I think Judge Tuttle pushed them to go to Hattiesburg and have a trial. Think of it. 3 judges on the Court of Appeals, one from Atlanta, one from Texas, one from Louisiana, getting off the bench of Court of Appeals bench and going to a little town in Mississippi and holding a 5-day trial against the registrar. And the trial took place at the same time that James Meredith was trying to enter into the University of Mississippi. And you'd be interested in how the lawyers worked. There was an author down there named Chase, and he wrote a book about Hattiesburg. And in one chapter of the book, he said he stumbled into the courtroom and came upon this voter discrimination case. And he said that he described the Civil Rights Division lawyers, and he described them as being putter-oners, looker-uppers, or run-arounders. And
say it again. What were those 3?
What?
Give me those 3 again.
Putter-oner, looker-upper, or run-arounder. Now, the run-arounder was a lawyer like John Rosenberg or Dick Parsons or would go out and subpoena 50 of white citizens of that county who operated the worst-looking farms. And they'd come in and sit in a room where they were waiting to be called as witnesses, and Bob, with his soft Texas accent, would go around and interview them. And it wasn't very long before Bob was able to, in a kind of a nice conversational way, have the person tell him that they only had two years of education, or they couldn't read, or they only got to 6th grade. And he was, in effect, the runarounder. He found the good witnesses, and he'd pass them in to somebody, and that somebody in that case, I guess, happened to be me. And I had the fellow next to me, a looker-upper, who had a big box of these registration records, and as soon as he heard the name of the witness, he was able to dig in that box and get out his application form, which was just a terrible looking piece of paper, if it was in his own handwriting at all. And then the next witness would be a black citizen, school teacher or farmer, who had filled out a decent to exceptionally attractive application form, who was being rejected. Well, that 7 or 8 days before these 3 judges in the Court of Appeals, by that time, Judge Wisdom and Judge Brown, I believe, had really got mad at the Mississippi lawyers and the junk that they were throwing at them, of the arguments they were making about the Constitution. And at the same time, Burke was getting frustrated with the fact that we were going county by county. And so he gave to Dave the assignment to draft a case against the states of Louisiana and Mississippi. And Dave did that. And we brought those cases. The Louisiana case was before Judge Wisdom and 2 others, and there were 3 judge courts. And the Mississippi case was before Judge Brown and Judge Cameron and Judge Cox. And one of the remarkable things about it was that Dave put in the allegations of the complaint that because of the segregation in Mississippi, which was total, that the quality of education between white citizen black children in Mississippi was just the difference between night and day. And because of this unequal education, Mississippi was really powerless to make any voter qualifications based on education. And he argued that all of the qualifications in Mississippi should be swept away, and everybody should be entitled to vote on the basis that white people had been allowed to vote in the past, and that was if they were a resident and they could breathe, they voted. And that then Judge Wisdom and Judge Brown wrote these magnificent opinions about the history of segregation and the corruption in the voting, just absolute straight-out fraud, of 100 years of fraud in the election since the 15th Amendment was passed. And there were marvelous legal literature. And I think that case and those 7 days that the judges spent listening to the registrar in Hattiesburg made a difference and had some significant impact. As Charlie said at the beginning, it caused the Congress of the United States to sweep away all of the old traditions about that the qualifications of voting should be left to the states, individual states to determine, and that there was nothing un-American about wanting to have an intelligent electorate. And what we had to get over was to get past that, and so that we could get black citizens to register on a wholesale basis and get enough of them registered to vote so that they make a significant difference. And that's what happened with the 65 Act.
Just add a word.
Sure, yeah.
Just a half moment. That condition I described in the South also permeated law enforcement, and the practice of law. And there literally was no law when it came to violence inflicted on African Americans. There was no law. It permeated every police department, infected by the Ku Klux Klan. It affected the FBI, 1 or 2 agents in most of those communities locked in to local law enforcement trying to cooperate on federal crimes, but well aware of the absence of law enforcement. And of course, J. Edgar Hoover had no commitment whatever, so there was no real interest on the federal level among those agents to help enforce the law. And someone asked earlier about Harold Cox, a Kennedy appointee. He was part of the system, as corrupt intellectually as anyone could be. He wouldn't have been there had he not been a bald-faced liar, lied directly to Robert Kennedy to get appointed. Same must be said of Senator Eastland, lied to get him appointed. I mean, Judge Cox and other federal judges like him, not to mention so many state judges, were a disgrace to the concept of equitable judiciary.
Can I just read to you, that's what I was opening the machine for, a letter from Judge Cox to John Doar. This is wonderful. Dear Mr. Doar, I have a copy of your letter of October 12 regarding the above case, and thought I had made it clear to you one time in Hattiesburg that I was not in the least impressed with your impudence in reciting the chronology of the case before me, with which I am completely familiar. If you need to build such transcripts for your boss man, you would better do that by inter-office memoranda, because I am not favorably impressed with you or your tactics in undertaking to push one of your cases before me. I spend most of my time in fooling with lousy cases brought before me by your department in the civil rights field, and I do not intend to turn my docket over to your department for your political advancement. You have been given every consideration and every courtesy in my court, and I don't think that you have any sense of gratitude or appreciation therefore. You are completely stupid if you do not fully realize that each of the judges in this court understands the importance of this case to all the litigants. I do not intend to be hurried or harassed by you or any of your underlings in this or any court where I sit. And the sooner you get that through your head, the better you will get along with me, if that is of any interest to you. I do not think the very important actions in this case should be shelved just because you are in a hurry to make some kind of showing in your docket, and I shall not vote for any such irregular and completely improper procedure simply for the advancement of your political goals. Signed, Harold Cox. All right, so just to bring it to a little close and then open it for questions. Yes, the thing that's so impressive about this story that starts with Bobby Kennedy adding 4 lawyers to the division is that a process starts, a law process, a process that at its base is energized by, I think, the spirit of John Doar, a man who just totally believes in the law and in the facts and in the ability of truth to make a difference, and understands that people live in fictions, and that if there's a possibility of presenting the truth, you can educate people. And this story is, to me, just a remarkable story of the Civil Rights Division educating first the judiciary, the federal judiciary, and then secondly the Congress of the United States. The idea that 5 years after this began, the Congress of the United States would pass the Voting Rights Act that embraced this strategy that Dave Norman and Bob Owen and John Doar had put across, of recognizing the disparity in education and actually removing the qualification and opening up the vote to the massive registration of black people. That's an incredible story, and I just think you deserve a Nobel Prize, John.